I'm reading out of the Barbri outline for real property on page 131, starting with title search. Suppose A has contracted to sell Blackacre to A. Suppose O has contracted to sell Blackacre to A. Prior to closing, A, the buyer, will have a title search performed to assure herself that O really owns Blackacre and to determine if there are any encumbrances on O's title. How will A's title searchers proceed? There's a tract index search, B, a grantor and grantee index search. Let's see if there's more. C, other instruments and events affecting title. So, for tract index search, in the tract index jurisdiction, the job is comparatively easy. The searcher looks at the page indexed by block and or lot describing Blackacre and at a glance can see prior recorded instruments conveying, mortgaging, or otherwise dealing with Blackacre. B, in the grantor and grantee index search, the search is much more complicated in a grantor and grantee index jurisdiction. For example, V owns Blackacre in 1935 and 1965. V conveyed Blackacre to W in 1990. W conveyed Blackacre to X. In 1995, X gave V Bank a mortgage on the land, a mortgage on the property. In 2005, X conveyed Blackacre to O. O contracts to sell the land to A. A's title searcher will look in the grantee index under O's name from the present back to 2005 when she finds the deed from X. Then under X's name from 2005 to 1990 when she finds the deed from W to X. Then under W's name from 1990 to 1965, then under V's name from 1965 backward. The searcher will then look in the grantor index from under V's name from 1935 to 1965, under W's name from 1965 to 1990, under X's name from 1990 to 2005, and under O's name from 2005 to the present. In this manner, she will pick up the mortgage to B Bank, which was recorded in 1995 in the grantor index under X's name. And there's a depiction of this with O. Maybe this is another example because it starts with O and there's a line to B in 1990 and there's a line to A in 1980. And what we have is some letters. I think R means recorded and NR means not recorded. So I guess first is in 1980 O conveys to A. Then in 1990 O executes an identical conveyance of Blackacre to B. B pays valuable consideration, but B has actual knowledge of the prior unrecorded conveyance to A. B records. A records. So B records in B records in 1990 and A records in 2000. However, in 2014, B conveys his interest in Blackacre to C, who purchases without notice of the conveyance to A and who pays valuable consideration. In searching the title, C will first look in the grantee index under B's name to discover if his seller B ever acquired title. He will find that B acquired title in 1990 from O. Next, he will look in the grantor index, discover B's name to discover if B made any prior conveyances, and then we'll look in the grantee index once again, this time under O's name, to discover if O ever acquired title. C will find that O acquired title in 1970. Then he will look in the grantor index under O's name to discover if O made a conveyance prior to his conveyance to B. Under the majority rule, C is required to look under O's name in the grantor index only through 1990. C will find no conveyances. In 1990, C will find the recorded conveyance to B, and he need look no further. On this basis, C will not find the recorded conveyance A, because A recorded after 1990. A's recording is out of the chain of title, and therefore C is not charged with notice. And I think that's in the minority of jurisdictions. So under the majority rule, C is required to look under O's name in the grantor index only through 1990. So actually in the majority of jurisdictions, the O to A recording being done after 1990 will not be found because it's out of the chain title and it will not serve as record notice. Under a pure notice or race notice statute, as between A and B, A will prevail because B, having knowledge of A's unrecorded conveyance, is not a protected party. However, as between A and C, many courts hold that C would prevail because A's recording is out of the claim of title. The cases are split because notice is irrelevant under pure race statutes. B would prevail over A because B recorded first. Once it is established that B prevails over A, C obviously takes good title. Other instruments and events affecting title. The title searcher's job may be complicated by marriages and divorces. For example, a woman's name may have changed between her appearance as a grantee and her reappearance as grantor, and by the fact that a number of interests in the land may be filed and indexed elsewhere than in the recording office. For example, judgment liens may appear in the trial court's judgment docket. A tax lien may be filed only in the tax assessor's office. Similarly, discovering whether land has passed by will or intestacy rather than by conveyance may require a search of probate records. Effective recordation. Proper recordation gives all prospective subsequent grantees constructive notice of the existence and contents of the recorded instruments. For example, there can be no subsequent bona fide purchasers. Recordation also raises presumptions that the instrument has been validly delivered and that it is authentic. These presumptions are rebuttable, not conclusive. A does not validate invalid deed. B does not protect against interests arising by operation of law. So, this is the effect of the recordation. As stated earlier, recordation is not necessary for a valid conveyance, nor does recordation validate an invalid conveyance, such as a forged or undelivered deed. So that's why we say it does not validate an invalid deed. And B, the effect of recordation does not protect against interests arising by operation of law. Furthermore, recordation does not protect a subsequent purchaser against interests that arise by operation of law rather than from a recordable document, for example, dowry rights, prescriptive and implied easements, title by adverse possession. Because there is no instrument to record in order to perfect such interests, the recording acts do not apply, and subsequent purchasers take subject to the interests. Remember, if the recording act is inapplicable, the common law priority rules apply. For example, O is the record owner of Blackacre. X adversely possesses Blackacre for the period of the statute of limitations. O then conveys Blackacre to A bona fide purchaser. Even though X's interest has never been recorded, X prevails against A. Exception. A court may protect a subsequent bona fide purchaser from an unrecorded implied easement that is not visible upon inspection of the premises, for example, an underground sewer. Recorder's mistakes. C. An instrument is considered recorded from and after the time it is filed at the recorder's office, irrespective of whether it is actually listed on the indexes. If the recorder's office has made an error in recording, the subsequent purchaser has an action against the recorder's office. There is a strong minority view that protects the searcher. D. Effect of recording unacknowledged instruments. As discussed above, the Recording Acts require that before an instrument can be recorded, it must be acknowledged by the grantor before a notary. What happens if the recorder, by oversight, records a deed that has not been acknowledged or has been defectively acknowledged? No acknowledge means no constructive notice. Because an unacknowledged deed does not qualify for recordation, it does not give constructive notice or to subsequent purchasers. Hence, unless the subsequent purchaser has other notice of the earlier deed, the subsequent purchaser will prevail. Example: O conveys Blackacre to A by a deed that is not acknowledged, but the recorder nevertheless records it. Later, O conveys to B by an acknowledged deed, which B records. B prevails over A because B had actual notice of the deed from O to A, which she might have if she searched the title records, or inquiry notice as she would have if A was in possession of Blackacre. 2. Compare defective acknowledgement. When a recorded instrument has been acknowledged, but the acknowledgement is defective or for some reason not apparent on the face of the instrument, the better view is that the recordation does not impart constructive notice. Rationale: a hidden defect in the acknowledgement should not be allowed to destroy the constructive notice that the document otherwise clearly imparts. Purchasers should be entitled to rely on what appears to be a perfectly recorded document. Example: a deed bears what appears to be a valid acknowledgement but is in fact invalid because the notary was disqualified to act or because the grantor did not appear personally in front of the notary to acknowledge her signature as required by law.